You're muted.
Okay.
There we go. Okay. There we go. All right, so we had a few people coming in.
Okay.
We can we'll hang out a few more minutes to get people and get them settled and set up.
You see stuff on me. There you go. Are they in the waiting room?
No, so they're coming in.
Okay.
Yeah, which is fine. I would love to have like elevator music playing to greet everyone, but we've been having struggles with that.
Oh, my husband has all his backgrounds and everything. So, but he was trained on Zoom before the thing hit. So
he knows all of the tips and tricks to make it look professional.
He actually likes teaching online better than he likes teaching in person. So it's kind of interesting.
I can see that. You don't have to like worry about pants. That's the only thing I would think about.
Yeah,
that's the best.
I put on my big girl clothes today. I usually don't do that.
I did too. So first night sweats. So I feel accomplished. Sense of accomplishment. You know. All right. So I think we can kind of get started. Other people will continue to come in. As they do, they'll be muted. And then, like I said, we're going to record this. So if anybody misses anything, do not stress. The internet has it. All right. So I am Anastasia Simon. I am the managing director of Shadow Labs at Shadow Ventures. We are a seed stage investment firm based in Atlanta, and our focus is on investing in tech companies in architecture, engineering, construction, commercial real estate, all those good things. And today we're going to be talking to you guys about IP. Well, not we, because I'm not an attorney, but we do have an amazing one here who's going to kind of give you the ins and outs of what you need to know as a startup looking for IP. So Jackie, I'm going to hand it over to you and let you introduce yourself and kind of set the tone for what we're going to be discussing today.
Okay, thank you, Anastasia. I'm Jackie Hutter. I have a consulting practice that I work out of my home in Decatur, Georgia. I've been in the IP business for more years than I really like to admit. It's a lot. I started my career as a litigator at a big firm. Then I moved over to a more a practice where I got to go home occasionally, unlike what it was when I was a litigator, where I became a very well trained and well compensated patent prosecution attorney at a local law firm here in Atlanta, local law firm for a number of years. And then I took a big jump, took a big risk, and went to work at Georgia Pacific, where I was a senior IP person in the consumer products, the Dixie business, and then in the chemical business also. And from that collection of experiences, I then left Georgia Pacific during the last downturn, and I reinvented myself as an IP strategist. Because what I had realized is that the work I was doing to support the business while I was working with the folks at Georgia Pacific was much more interesting, much more value creation focused. And quite frankly, it interested me a lot more than just running an assembly line of writing patent applications or filing briefs in a litigation. And over the years, with a couple of side steps where I ran a startup technology company for a number of years, and it lived and breathed lean startup, and understand more so than just about probably any other lawyer out there that you'll meet what it means to be an entrepreneur, a startup entrepreneur, early stage company. I then jumped back into being a IP strategist with a very precisely selected client list. For the last many years, I have worked exclusively with innovators. Innovators are typically startup and early stage companies that are making a big change in the market for their validated consumer, but also larger companies or smaller established companies can also be innovators when they're actually working to not just do incremental product or technology changes for their customers, but actually seeking to move the needle significantly. And from my experience working with almost exclusively with innovators, and being a startup entrepreneur myself, I have effectively reframed the IP process from that vantage point. I'm so part of this ecosystem that looks at value creation as the driving metric for IP and patent. I'll use IP and patents interchangeably. I'm primarily a patent person, but I'm also an IP strategist. So I just wanted to give you a call out on that. But I have the vantage point that I look at is not whether you can get patents or IP, but whether you should get patents or IP, because it allows you to achieve a desired business outcome. In other words, the business outcome comes first before you even think about whether or not to get patents or IP. And then you decide whether or not the patents or IP are going to help you get to that desired result. I'm a very different thinker. I wasn't planning to have a webinar when I dyed my hair purple, but you can see that's probably will probably look a lot different than a lot of attorneys, especially experienced attorneys you've worked with in the past. My license plate on my red Mustang convertible is unlawyer. So this is me. I'm very straightforward about what my viewpoints are, but those viewpoints are from a prism of deep and relevant experience over a number of years. Of course, what I'm going to be talking about today, when we open up the table for questions, it's not legal advice. We don't have a professional relationship. We've never met. So I want you to realize that I'm not just talking to you here. I have a podcast. I've been blogging for 12 years. My viewpoints are very well known. So we always have to check ourselves as lawyers. I am a lawyer. I do pay my bar expenses, but I am more of a consultant these days. Actually, I am a consultant these days. But don't think that you're going to be able to walk away with the stuff that I tell you here and take it to the bank. You need to hire somebody, and it does not need to be me. I hope to leave you with a lot more of knowledge than you came in with. And importantly, to the extent there's any lawyers on the call or anybody who knows lawyers or the lawyers who may know me, I want to make it very clear that this is not meant to be a criticism of any individual lawyers, but rather it's a criticism of the business models that lawyers have been working under for many years. The law firm, the lawyer business models can often put the business interests of the lawyers first. In that regard, 100% of patents make money for 100% of patent attorneys, but very, very few, as I'll talk about in a few minutes, actually make money for business. And that disconnect is really bad for businesses, but not so bad for lawyers, because lawyers always get paid, right? And what I've found very distressing over the years is that innovation requires, in every context, requires the reevaluation of business models to see whether or not you can deliver products or services in a better way for the people who are buying them. That is, in this case, in the context of law firms, clients. And I've been in or adjacent to the law firm business for over 25 years, and the models have never changed. How lawyers deliver services hasn't changed, even while the rest of us have changed dramatically. So, I've spent a lot of time over the last many years advocating the need for law firms to change their business models. But what I realized is that law firms won't change. They won't provide you better services and better value until you actually make them. So the best way for me to affect change is to point out from my expertise and from examples how your delivered service as clients don't serve your needs. And that's why I like to do forums like this and make you think perhaps differently about patents and IP going forward. Um, as I said, I've been blogging for about 12 years now. You can find a lot of my blogs are on my LinkedIn page, and I welcome you to go there, Jackie Hutter on LinkedIn. And I recently started a podcast, which I dropped the first season, which is called Winning with Patents and IP. And so anything that you may want to pick up after this call if you find some of the stuff I talk about interesting, feel free to go to either my blogs or my podcast, whatever suits you from a learning perspective. And I'm sure that you'll find those interesting. So I guess I should say, in addition to my years of experience in a law firm and as a consultant and stuff, I have been named a top IP strategist by my peers for each of the last 12 years. So what I do is, there's nothing special about what I do. There's people all over the world who do what I do. It's just a new business model that may not be familiar to you until you've been introduced to it. So Anastasia asked me to just talk for a few minutes, and I will, just to set the stage and perhaps give you some ideas about what to ask me during the question and answer. So as I said, 95% of patents fail to create business value. That's a number that's not mine. That's a number that's from some of the largest corporations in the country who actually manage their IP in an effective manner. So this means that only 5% of patents done by the people who do the best job perhaps in the world create value for them. And if they can't get it right, you got to be darn sure that most of the rest of you are not getting it right. And what this 5% creating value are is that the way I characterize it for folks is that there's these 5% of patents are actually move the needle on creating value for the company. That is, they're strategic. They affect they change the way competitors look at the marketplace. So that's obviously a very small number. I think that most people enter the patenting process thinking that their patents are going to be valuable at the end. And if I actually had the conversation with them that if you do it the regular way, it's actually going to be more like 5%, if you're lucky, are going to end up creating value. It looks like a pretty lousy number, and you might want to rethink that. And if you think about it, if a company like IBM that gets 3,000 patents a year, roughly, if they get 5% of their patents that create strategic value, that's a real number, right? That's 150 patents. But if you're a smaller company, a startup that's only getting 1 or 2 or 3 patents, 20%, you may not even be leaving the gate on that. So that's a really distressing conversation to have. And I do have to have those conversations not infrequently when somebody comes to me and talks to me about, as a second opinion or come in and take over a matter. And I have to say, quite honestly, far more often than not, I have to tell them that what they think their patent covers or will cover is absolutely not that case. And that's after all the money's spent. So I much rather get to talk to folks before they start the process, whether they hire me or not, because as I said, anybody who comes and talks to me and gets my information is going to be in a much better place to actually direct their own efforts going forward. But for other companies, the fact that, like I said, only 5% of patents matter, but have value, but that's okay because patents rarely matter. And that's another big secret. When I said the truth about patents and IP, that's true. They rarely matter because they're not something that is going to drive a business value creation inside an organization. Let me use my former employer as an example. At Georgia Pacific, we had distribution channels, we had customers, we had manufacturing plants. We were a vertically integrated company. And when we failed with a new product, the company didn't go out of business because we had all these other adjacent assets, all these complementary assets, as they're called by the B school types, that kept us going. Now, was it disappointing if a product failed? Yeah, certainly it was, because we put a lot of work into it. There was a lot of investment, and expectations weren't weren't affected in that regard. We had other situations that I can't talk about, but I can say generically where the product was very successful, but the patent strategy was not. So we still had a successful product introduction, but the fact that our patent strategy failed meant that competitors could come in and provide a competitive product, which caused us to be no longer in an exclusive market like we'd intended when we went into made the decisions to make the investment to go into that market. We were still in those markets, but we weren't making as much money as we expected to make, because the patents did not end up serving us well by way of competition. And we probably have some questions on that later, that to the extent I could talk about that generically, I'll just leave it at that. So bottom line is that not getting the right kind of patents that you need in a particular situation, especially when you're an innovator, can cause you to leave a lot of money on the table. And for big companies, that's okay, right? Because they're not going to go out of business. But quite frankly, startups have only one chance to get it right. And if patents are a key driver of business value creation for you, you better get it right on the first order, or you're not going to have any other chance to get it right. I like to tell folks also out of the gate what I think to be the three big mistakes that I think most companies make, but they're more important for early. The first mistake is not understanding that the goals and expected outcomes of a business plan are in most cases highly influenced by skillful alignment of your IP or other intangible assets with the company's business strategy. That is, business strategy requires some sort of IP or intangible asset value creation to be associated with success. And let me unpack that briefly. We know what patents are, and there are also trademarks, trade secrets, and copyrights are the demonstrable form, the legal, I should say, the things that we lawyers, putting on my lawyer hat, the things that we lawyers talk about all the time, and we like to talk about them because they're very understandable to lawyers because they're legal rights. But there's a much broader rubric of value that's intangible assets. In fact, IP is a subset of the broader class of intangible assets. And all of those things that have value or potentially have value in a company, if you don't name them, you can't claim them. Okay, so if you don't know what your trade secrets are, if you haven't captured them, they don't exist and they can't end up in a balance sheet. I can't tell you how many times I've had a company tell me that they protect themselves by trade secrets, and I say, what are they? And they can't articulate them. If you can't articulate them, you can't sell them, quite frankly. Other forms of intangible assets that folks don't realize is employee expertise. Key employees that if they went away wouldn't be there anymore. And again, if you can't name them, you can't claim them. So so if you say that my expected revenue in 2 years is going to be X, and you can't also say, and this is why I think I'm going to be able to get X, because I've got a key employee who's got stock in the company, and they are going to be more likely to stay with me than to go out and compete with me, then you really can't say for in good conscience that you're going to be able to realize that number. So that employee, that key employee, the fact that they exist is in fact an intangible asset, and which is not quite IP. It's adjacent to IP, but it's part of that intangible asset creation that you have. So you have to, again, if I leave you with one thing, other than the fact that most patents stink, is that you have to, in order to have the value, you have to be able to name it, or else you won't be able to claim it. The second mistake that I think that folks make quite frequently is listening to conventional experts, conventional wisdom from patent experts and investors about patents. I could go through a litany of of things that's wrong here, but what I find most telling is a story that from a recent meeting I went to. I'm part of a lot of I guess fancy patent law lawyer things here locally, and before the lockdown, I would go to the luncheons and stuff and talk to other folks. So the last luncheon, actually, and I think about it, the last luncheon before lockdown was at a big law firm in Midtown Atlanta with a bunch of IP folks. And the subject for the luncheon was having a local VC come and talk to some very experienced patent attorneys in the area about how investors value patents in the balance sheet and in the Series A context in the local environment. And I was expecting to learn something, and was was very disappointed that I walked away with the full validation of my previous concept that patent lawyers are from Mars and investors are from Venus, because the very experienced VC got up in front of a room full of very experienced patent attorneys and said, we really don't know how to value IP. And I know this to be the case because I have been involved in due diligence in Series A with some of my own clients. And a couple of those clients have successfully gotten more out of their term sheets because they've been able to explain to the investors why they were being undervalued by the investors, because they weren't properly characterizing the effect of the IP to my client. And they're my clients, so I know their IP, and it's and was part of their business strategy. So investors aren't going to be able to tell you in the abstract whether your IP is good. It's going to be your job to tell them why your IP is good. On the flip side, you also have to be able to tell the patent experts that you're hiring to do your work why IP is going to drive value. You can't listen to a patent attorney say, you need a patent. You have to be able to tell the patent attorney, I need a patent that covers this, and this is how I think you should do it, and then give it over to them to do it, and then importantly, properly manage them. Because they're not going to be able to do that because it's a business issue, not a legal or an investment issue. And they're probably not going to give you good advice because, in fact, they don't know what your particular situation is. The third big mistake that I see folks making is not realizing why you're getting patents and IP in the first place. As I indicated, most of the stuff that I come in and look at and to give an opinion, either for due diligence or to see, can I license this? Can I monetize this in the secondary market? Or can I enforce this against one of my competitors? The answer is usually no, unfortunately. And one of the saddest things I have to do, and I've had to do it so many times in my career, including recently to a client who's become a very close friend, that had me come in and take management of his portfolio, is that the patent that you spent all this money on doesn't cover a product that's actually being sold in the marketplace today and that's being very successful. That's a tough conversation to have, especially when the client expected to be able to license that patent or even enforce that patent in litigation against somebody because they have they thought that they owned that property, and they in fact don't. The fundamental problem, now to speak specifically about patents here, is that you don't get patents to cover the past. You get patent protection to cover the future. However, when you talk to your patent attorney, the first thing they ask you, and this is how I was trained, and this is how I did it for years, the first thing they ask you is, what did you invent? And then we immediately get grounded in the past. And what you end up protecting is what you did in the past, not the value you seek to capture in the future. My clients don't come to me to do that. They come to me they can capture the revenue that they think they are due for all the hard innovation work that they're doing. That they can get licensing for somebody who wants to take their innovation and bring it into their own organization, or more usually to enhance the exit value, to make it cheaper for somebody else, to go through them than around them, is what I like to say. I also say to folks, you don't patent for the company you have today, you patent for the exit you want or the future that you want. And contextualizing this into the framework of what you should cover, it's very similar to the marketing situation, where you don't sell the features, you sell the benefits. Customers don't care about your product, they care about the value you're providing to them. And if you're getting patent protection that doesn't properly encompass the value you're providing to them, you're leaving it open for your competitors to come in and provide that same value without having infringement or needing to license you. And the same thing goes for other forms of IP and intangible asset. The question is not how to protect what you're doing today, but rather how to define the future state and figure out how to align that IP or intangible assets with that desired future state. And quite frankly, trying to figure out how to get to where you want to be in the future is the definition of strategy, for what it's worth. Couple more key points that I'd like to call out. For whatever reason, and again, this is not a criticism of individual lawyers, but it is a criticism of the business model. I have, in my career, it has been very rare for me to come across lawyers who, patent lawyers who are willing to be accountable for the work that they do for their clients. Without going into a lot of detail, there is case law out there that says that a patent attorney has to get you a legally sufficient patent, and there's no liability for getting you a worthless patent. In other words, a patent attorney has to get you a patent. Their job is not to get you a valuable patent. Well, why are you going to a patent attorney in the first place? It's not to just get a patent. I presume it's to get you a valuable patent. And you need to recognize that unless you properly manage that process, it's quite likely that you'll end up not getting a patent that's going to create value for you. And holding your attorney accountable for that is a hard conversation to have. Some attorneys don't want to have that because they think you're going to sue them. But it's not about making liability. It's about making sure that you're getting what you came to them for. I can't, in that regard, I can't guarantee somebody's going to end up with a patent that effectively creates value for them, because there's lots of misses. But I can guarantee that if we have the right framework now, while the patent's being prosecuted, and by the time it issues, it's going to be more likely to hit the goal. In other words, I can coach you to desired result. And if that's not done in the first order, you can almost be very guaranteed you're not going to get it. And the other thing is, I want to point out is, for whatever reason, perhaps it's just of a lack of content experience and the incentives to be accountable and to wonder what went well, what didn't go well in a particular situation. I find that most attorneys that are out there that you might hire today just seem to have the same tools in the toolbox. But there's a lot of tools in the toolbox, available toolbox of tools that are properly deployable for different companies in different situations, and even the same company that's in different situations. And I very often have a conversation with clients about whether or not we should perhaps choose an option that keeps a patent application confidential, because you don't know what the future is going to hold, as opposed to doing the standard methodology of filing a patent application that's going to be published in 18 months from the original filing date. That actually just happened today. I have a company, actually a university company, spin out company that humanitarian cause, but also lends itself to a commercial application, and their grant money's run out, and we have to make a office action filing response, or else the application is going to go abandoned. And they're out of money. They can't use money to pay our lawyers to get this done. So that optionality of not letting the patent application publish means that we can now abandon this patent application, and in the future, when money comes in, we can then file this patent application and go forward with it. But that would not have been possible if it had gone the standard way of publishing the application, which is what most patent attorneys do. They just don't. You have to, in order to get something to not publish, you have to check a box. Most of the times, people don't even look at the box, and so it's by definition the conversation doesn't happen. Similarly, for most of my startup clients, and even some of my larger clients who are doing innovation, they're going to want to push a patent application out of the patent office quickly, because that in innovation, speed is key. And certainly with startup companies, having an issued patent that covers your product that you're scaling at this point, and that issue that's allowed in a year, and I've actually gotten a couple allowed in less than a year. Having that optionality is really important if your business strategy is contingent upon your having some sort of protection. I indicated one of my startup companies that I've been working with for several years explained got a bump in their Series A last year. They got a bump in their Series A of 20% because it's a very patent intensive technology area, and the CEO knew that going in, and we've developed a very robust portfolio under which most of the patents have been allowed in less than a year. And we're able to build up a very robust portfolio that could be valued at where it was in just a few years. To allow the Series A to be much more successful, and we expect in the near term for that robust portfolio that we've gotten in a fairly inexpensive manner will also bolster our exit value as we go forward, because we know the competitors are looking at our IP. And seeing that we're actually not just creating a great product, we're creating great IP. So, but that's a tool we don't always use. You don't always need to use it. Established companies, don't want to pay the extra money, especially if they're large companies, which is going to cost them a lot more to file a patent application. But I can tell you, when I see an established company paying the hefty filing fee, like recently saw an IBM patent issue under this procedure in less than a year, or I should say it was filed, so it was allowed in less than a year. You can also see whether or not the big company is investing more in a particular technology area by how much they're spending on the patent application. So it's a really interesting framework of things. So not all tools are the same, but you've got to have access, and you have to be able to trust your attorney to raise the right issues to allow you to select the right tools in real time. So I've talked for about a half hour here, it looks like, and which is more than the 15 minutes that Anastasia asked me to. So I think it's about time for question and answer. If anybody, I don't know if Anastasia's monitoring here, or is it what's going to happen?
All right, so I'm here. So everybody, if you have questions, like I mentioned earlier, you can drop it in the Q&A. So you'll see a button there, or you can put it in the chat. I already have one of our first questions from Kathy. She's saying by the numbers, so the numbers that you mentioned around IP and what is worthwhile. She's like, what can you do to increase that 5% significantly, and how much positive effect of IP innovation is possible?
So for the first, in the first instance, going into the process and understanding that 5% is meaningful in a particular context. For innovators, that 5% is, that 5% is only relevant, in my view, that 5% is only relevant to innovators, because innovators are creating a meaningful product or technology solution for a validated customer, which means that once you have validated that customer, and if the market's big enough, then your competitors are going to come in and say, thank you very much for solving that problem for me. We'll take it from here. So if your IP doesn't cover the customer value proposition, then your competitor is going to be able to come in and undercut you. And I'll use a positive example, which was not a client. So most of the negative examples I have are my own client experiences, or experiences, things that I've come in and looked at after the fact. But in any event, my favorite example here is one that's very familiar to most of us who have ever mopped a floor, is the Swiffer Wet Jet product. And if folks are old enough to remember, back in the old days, there were only a couple of ways to mop a floor, and one was a sponge mop, one was a navy mop, the rag mop, and also getting down on your hands and knees and wiping the floor. Those were basically how you mopped a floor. The problem with the first two of those, the sponge mop and the rag mop, were that in order to mop a floor, the first time you rinsed the water was dirty, so you never were cleaning the floor with clean water. And from an emotional perspective, if you're a mom whose baby's crawling across the floor, you have an emotional reaction that your baby is never crawling on a clean floor. And that was the customer value proposition, the emotion, the rank emotion that Procter & Gamble hit with the Swiffer Wet Jet product. They were able to create a product that you're always cleaning the floor with fresh cleaning solution, and that cleaning solution would never be reused when you were mopping the floor. And not surprisingly, all of the entire framework of that product drove recurring revenue in a razor and razor blade model to Procter & Gamble. That was a true innovation. There was a totally new way to mop a floor, and that new way to mop the floor created a $1 billion market for Procter & Gamble quickly out of the gate. Their patents, or their patent portfolio in this case, is to say, aligned with the customer value. All of their patents that they obtained made it impossible for somebody else to provide a product that allowed the person to mop with fresh mop water every time, with a clean pad, and all the stuff that went into it. There's a lot more detail in there, and I write about it on a blog. I've done a full teardown of the Procter & Gamble patents and the Swiffer. But that was a 5%, and how they did it, like I said, is aligning the value, and so that's how you do it. That's how you do it well. And I said we start with an invention. What did they invent? They invented a mop having a pad and a container of solution and all the stuff that went along with it. But that's not what they claimed. Their innovation was a truly new way to mop a floor. Does that answer your question? I guess, yeah, so I guess I can't get feedback.
So
Okay.
I got another question.
I just want one more thing, Anastasia. On the other one, I also don't want to leave the impression that there are 95% of patents that are worthless. From that same study that where the 5% came out of, and again, these are the best companies. These are Procter & Gamble is one of these companies. I know that through another source, and AT&T, Microsoft, IBM. It's all those folks that participated in this study. So like I said, the best people, the people who know how to do the best patents. But the other number that they said that came out of there was 25% of patents create some value. And how that fleshed out, if you actually look at how they describe the sum value, is they cover a product in the market. They don't change the way the market, that they don't change the market dynamics. They don't prevent competitors from providing the same customer solution, but they do cover a product. So in situations where there's incremental improvements that very often happen, in an established company setting, where you don't want a competitor to knock off the product, but there's really nothing truly innovative in there, then a lot of patents are meaningful because they just do that. They just cover what's actually being done in the market. And that's more of a present state of patent, not a future state of patent. And those patents are okay. You just have to name them and understand that's why you're getting a patent. But I would dare say that most of the patents that end up covering anything that are done by in the traditional way today, if they do have any value at all, they are in that 25% range. But that leaves 70% of patents that these best companies, the folks, the smartest folks in the room, if you will, were judged as having no real value. So, okay, so Anastasia, I just want.
All right, and I think kind of going off of that, this question is about patenting a process. Okay, so is it possible to patent a process? For example, a construction process that would cut construction costs by 50%. Now you're using existing materials, you're using existing products to do this. It's just how you're doing the process.
So I've actually got clients in the construction technology space, so I can speak directly to this. So you are providing a customer value. It may not be the customer value that's obvious to you may not be the customer value that you should patent. And an example of this, and I'll have to be careful because I am able to talk about this on a one-on-one situation, but in a public setting that's recreated, I don't feel comfortable doing this, so I'll genericize this a little bit. I have gotten the client's approval to talk about this, but in this unmanaged setting, I feel uncomfortable doing so. There had a client a few years ago, actually a good friend of mine, who came to me and he said that they were doing something in a large construction space, and it had to do with basically counting things. And I said, well, you can't do that. You can't get a patent on that because counting things, there's nothing new about counting things. And it actually sounds like a business model to me, and business models are exception to patenting. He says, no, Jackie, we go and talk to these large construction management firms and they say, we need what you have yesterday. That's a huge problem. And I was still kind of dubious. And that led to a big light bulb moment for me. But he said, Jackie, go search it and tell me this is not a problem. If you tell me it's not a problem, then I'll drop the patent and just go forward with the other stuff. But I do think it's a big problem. And sure enough, I went out there and I found out it was a really big problem, actually in the academic literature, because this counting problem made it so that people didn't get paid. Let me leave it like that. And people not getting paid made it, resulted in a lot of litigation. And and for me, I got to move, it was like, oh, lawyers are getting paid and people aren't, that's bad. That's kind of like the way when a lawyer gets paid before somebody who's doing the hard work, that bothers me a lot. So I went through and the key thing about the counting here, I think I can talk about this, was that it wasn't about the counting. It was about the counting in this particular context. And the context was that you have a large project in Atlanta. Mercedes-Benz Stadium was going on at the time, so it was really easy to point at that. But you have a really complex environment where things are changing all the time. And 1 week there may be the whole environment may be totally different. So how are you going to count things using a machine when there's no ground truth, if you will, because the ground truth changes every week? And they had a very simple solution to be able to count something in this environment that changed rapidly from week to week and month to month. And that counting was accurate, so that the counting, that the lawyers were taken out of the picture, at the end of it because the counting was accurate. And so it wasn't a business process. Yes, it was a business process because we were counting, but we actually put it in the context of being able to get better information out of the end of the process. And the better information was actually the value we were providing to the customer. And what was interesting in that respect is that, and I can't overstate that I actually told him it wasn't patentable. Because this was just if you will, a ubiquitous accounting in this accounting things was and still remains ubiquitous by Silicon Valley startups. Everybody wants to count stuff. And they have machines that can better count stuff, as a lot of people probably would appreciate. But by setting up the patent application in the framework of the value that we were providing we're getting better information because we count. The counting enabled the better information, and we got what has rarely happened in my career. I have to say that we got a first action allowance. The patent examiner said, you know what? You effectively, the purposes of this conversation, the patent examiner said, I was really surprised that I wasn't able to reject you, but I can't reject you because I can't find any prior art that sits on top of you. But super important here, it wasn't just how well we told the story. It was how we drafted the claims, because what the examiner thought when we could tell this by the tone and tenor of his conversation in his allowance, was that he thought we were asking for just a little bit. He thought our claims were very, very narrow. And in fact, they were narrow, but they were very broad in a $100 million market. So we effectively had a whole product solution covered in a relevant market that, to the patent examiner, given the prior art that was in front of him at that time, it actually looked like narrow claims. So it was totally in context. So in the the construction process space, I could tell you it's absolutely doable, but you have to, what you have may not be what you need to patent. You need to look at it from the vantage point of the customer, as well as differentiating yourself from how everybody else has described it in the past. And another one of my clients is in the construction, computer vision and construction management space. And I can also say that I've done that effectively a number of times for them too. Not claiming the process, but claiming the value that's provided by the process.
That's great insight. So taking it deeper in construction. So the design and construction industry has typically not embraced patents as a method of protecting their IP, and they usually take the trade secret approach. When would you suggest using trade secret versus IP, versus a patent to protect IP?
So without knowing specifically what the situation is, it's impossible to say that. What I will say is that my client who's successful in the construction technology space now, and the one who got the Series A bump, has both trade secrets and patents. And we closely manage the alignment and the compare and contrast of what we're protecting as trade secrets and not as trade secrets. There's I guess the old-fashioned way of looking at patents is that in exchange for a patent, you also have to give up your trade secrets. And that's not necessarily the case. What you disclose is only a function of what you end up claiming. So for example, if I'm claiming, like in the example I told you about the counting things, we had a specific algorithm, if you will, that we used in our particular context to do the counting. But we didn't claim an algorithm. We claimed a result. And so the algorithm was, which was our trade secret, did not have to be disclosed. And in the of actually taking this to market, able to say to the customers, hey, We've got a SaaS product. We don't download. You don't have access to the code. You only have access to the processing. And so we're not giving you access to any of the trade secret in order to use our technology. So we'll keep it as a trade secret. And I think that if you're not getting patents, then not allowing your customer, who may often be a competitor in these spaces, I know, not to then to have access to your code and only to have the results in the processing is a way to manage that. But I will say that in the areas of construction technology where I work, and of course I can't tell you, what those are, but you would be surprised how many patents there are out there and how important patents are, not to you as a startup or an early stage company, but to the to the companies that may end up acquiring you. Having patents is very often what I like to call technology virtue signaling. They not only see your successful product, but see how well your product is protected. And importantly, from a strategy perspective, I tell my clients always, if you're a startup and you're thinking about suing people, if you're talking about lawyers like to talk about this is a litigatable issue, or you have to worry about this in litigation. And I go, whoa, stop talking about litigation. That's not our business model, okay? And any issues that may arise in litigation are going to be somebody else's problem, because our goal is to exit this company and have it be scaled by somebody else. So, but that's why I, in the usual situation, because quite honestly, people come to me because they've understood in some way, either they've been told or they understood that they need patents. So I have a very my client intake is loaded for people who self-select for that. I should put it that way. But in that regard, when people come to me, they're going to say, yeah, I think I need a patent. Help me, walk me through this process and see if I'm right. And what I say to them is, forget about what we are going to do with these patents. We don't care what we're going to do with these patents, because we're not going to sue people. We may license them. So I have some clients who have licensed them while they're still in the startup early stage. But why we're getting these patents is for the company to which we exit to acquire these patents so they can use them in a way that's cognizant with their own business strategy. So as an example, if I'm going to sell, I have a client that did this a couple of years ago. I have a startup client that was in a particular space, machine learning space, let me put it that way, machine learning space that sold to a Fortune 10 company. That Fortune 10 company has thousands of patents. That Fortune 10 company was, didn't care whether they were infringing my client. That wasn't why they acquired us. They didn't acquire, but why they acquired us is for our trade secret technology that was not patented, our processes, our code, our 2 years head start in this particular area, which was really cool. We were very early in the area. But they also cared during the acquisition, and part of the exit the exit value that was provided to this company. Unfortunately, I didn't have equity in this company. Was due to the fact that this startup company had broad patent protection, or was in the process, as you say, of getting broad patent protection that would allow this Fortune 10 company to assert those patents against one of its competitors, right? Like I said, you don't patent for the business you have, you patent for the exit you want, and that was a pure example of that.
Awesome. So we got one final question. So this is from, I'm going to mess this name up, Razia. Thank you, Jackie. Great webinar. I'm working with a startup, navigating the conversation between the founders, patent lawyers, and product development experts. Everyone has a different perspective and no one agrees. Any advice regarding how to coordinate this and how to coordinate this to obtain appropriate IP for a cosmetic product? Founders say investors want it. Lab says it's not necessary as most cosmetics have no patents, and lawyers are suggesting a utility patent.
So you didn't know this probably coming into, but I have a graduate degree in cosmetic science, and I spent the first few years of my career before I went to law school at a personal care company. So it's not correct to say that most cosmetics don't have patents. That's if you went through and looked at the patents that are done by the incumbent companies, it would boggle your mind how many patents there are out there. It's kind of a way to say it. Now you're absolutely right though, and what I think I heard there is you don't want a patent for. I'm actually working with a company that's working on disinfectants for COVID-19. Disconnect, somewhat of a disconnect between the innovation team, the chemist, and I understand her chemistry because I used to be this kind of chemist, and the investors. And not the same story, but I'm dealing with this right now. And it's what I'm telling the chemist who came from a big company. And what the CEO, who's an innovation expert, also knows is you don't patent a formulation, because formulations are very easy to get around normally. Unless you're showing a true functional difference that has enough data that you can claim it, then you're effectively in the context of a cosmetic, a personal care, or other type of product like this, is the equivalent of, or is analogous, I should say, to claiming an algorithm when you can own the outcome. So presumably this cosmetic product provides a benefit to the consumer. Not knowing what it is, I can't spitball anything, but I'll use, since I was a hair chemist a million years ago, this kind of first thing that came to mind is that some hair care products will provide a different luminosity or shininess to the hair, and a lot of that marketing collateral has to be shored up by claim substantiation. Well, you can use that same claim substantiation to actually get protection on the product, so that you potentially would be selling a product that that provided this shininess to the hair, and your customer is buying the product because it provides a shininess to the hair, not because it's got X, Y, and Z ingredients in it. And then you would be able to prevent your competitors from providing a comparable product that provides that same shininess. And what I like to say is that in this particular context, I usually use a different context, but the formulation that you've come up with is enabling the good result to happen. It is not the end result. And if you can name the end result and have enough data, enough functional data and demonstration in the patent application to claims set up like that, it takes more work, it certainly takes more creativity, then a utility patent would potentially be the right way to do it. I used to work, if by any chance it's deodorant, because I know there's a lot of deodorants going on there. Deodorants are functional things, and you can measure smells, and you can measure activity and that kind of stuff. And those smells and activities are the benefit being provided. So you should be seeking to understand whether or not you can claim those. And your patent attorneys are probably not thinking in this context. They probably want to claim a formula because that's the way they've always done it. But in doing it that way, you're going to have to give away your trade secret, I fear.
All right. So looks like we are right at time. I want to thank you so much, Jackie, for doing this. I think you gave everybody a lot to think about when it comes to how to protect their IP within their company. And I want to thank all of the attendees for coming in and listening to this. This was great information. Everybody's going to get a recording. You're also going to get this as a podcast. You'll see we'll be promoting this a little bit later in the week. And then if you all have any questions, Jackie, can you tell them where they can find you online?
Sure. A lot of my stuff is LinkedIn at Jackie Hutter. I also have a lot about how I work and what my business model is at thehuttergroup.com. And whether you think may want to hire me or not, I strongly, which is not the purpose of this, of course, but sometimes it happens. I strongly recommend that you at least listen to a couple of my podcasts at Winning with Patents and IP, which you can find on my website, on LinkedIn, or on Spotify.
Awesome. So thank you so much. And you guys enjoy the rest of your week. Happy Hump Day.
Thank you.
Bye-bye.